Thank you, Chair. With your leave, we dealt with, in some detail with the circumstances of Mr. Mhlontlo's resignation after a process. Perhaps logically it would make sense for us to deal with that, although it comes in the latter half of his second affidavit. And
Yes.
if we can deal with all of that to complete the picture and fill in a few details.
Yes.
And then thereafter we will get back to the first affidavit and deal with
Okay.
some of the transactions.
No, that's fine.
Mr. Mhlontlo, I'd like you please in the bundle, and just for the record, it's bundle Denel 7, Exhibit W20. Mr. Mhlontlo, will you please look at page 587?
In 587,
You deal under the heading the suspension and later your resignation with the events that led up to what you told the chair about yesterday, which was the negotiations which took place parallel to the disciplinary process that never ultimately happened, the preparations for the disciplinary hearing, and how you ultimately were persuaded to take a package by way of a settlement. Now, I'd like to go back a few steps to deal with the suspension. You refer to your broad agreement with Mr. Saluji's evidence already given in this commission concerning the circumstances of the suspension. Is that correct?
it is indeed correct.
And then you refer to the fact that at a certain stage, Denel started dealing with you individually. So Mr. Saluji and Miss Africa and you were no longer dealt with as a three-person group. Is that right?
It is correct, Chair.
Now, you've already corrected on the record paragraph 5.3, which deals with an orientation, and you've corrected the date 24 July 2015.
Yes.
Now, you've referred there to the orientation and a special session relating to the LSSA transaction, and then at the foot of the page, the first meeting of the new board of directors. But what I'd like to take you now to is page 588, paragraph 5.7, where you deal with a meeting that took place on the 22nd of September 2015, where you met together with Saluji and Africa, Miss Africa, with the Audit and Risk Committee. Now, I'd like you to explain what happened at that committee meeting. What did you understand when you were called to attend this meeting that it would be dealing with?
During the course of the day on Tuesday, we were advised that we would need to meet with the audit committee later that afternoon. And there was no agenda per se, what the agenda that would be. I had a distinct sense that Mr. Saluji had a sense of what was going to be engaged on. As to why that was the case, I had no knowledge. And then the meeting took place. We were called one by one. We were presented with a letter that seemed to have been written based on the presentation we had given around the transaction of LSSA, and making various allegations, and we were then given 24 hours at which we would have to furnish reasons as to why we shouldn't be suspended. And I guess what was expected was that against each point we would provide reasons as to why the alleged issues happened the way they had been tabulated. And we sought legal counsel in between before the 24 hours was up, and we went with a broad response to the Audit and Risk Committee that's saying, given a more time, we're happy to go through each point and clarify. But I think what's important, Chair, is the fact that even on a one-on-one or on a meeting with the Audit and Risk Committee, I had put forward to them to say that, as far as I'm concerned, issues of governance aren't handled that way. We can't have a board that is 6 weeks in office. It has had one presentation, and the next thing is making a whole host of allegations. Even if those issues could be valid, one would put the questions to the board would, to the management, and management would respond, and it's only upon the Audit and Risk Committee or board not being satisfied with the responses that it could even be putting out a word along the line of suspension.
So this is now at the meeting of the 22nd September 2015. And the meeting is that of the Audit and Risk Committee, not of the whole board.
Indeed, Chair.
And the first meeting of the board had been on the 10th of September 2015, is that right?
Correct.
So the meeting of the 10th of September was the first board meeting.
Correct.
So between the 10th and the 22nd of September, no further board meeting had taken place, or had taken place.
Correct, except that Mr. Saluji had gone overseas to UK with the chair of the board, and there had been no board meeting.
Yes, there had been no board meeting. So the Audit and Risk Committee, was this its first meeting on the 22nd? Do you know?
The meeting, there was a meeting before that, which was specifically to update it on the LSA transaction, where we made a presentation of give or take 20 slides that says, here's a company, here's a background of the company, these are the circumstances under which it was bought, here's a PFMA approval, and all the processes we had followed.
Yes.
And the presentation was obviously a high level, ensuring that the board, the Audit and Risk Committee, was fully appraised of what had taken place in terms of decision. And there was one element that needed to be fulfilled by the new board, which was that of bringing an equity partner on that transaction. So it was quite important that we have that presentation. So there had been one Audit and Risk Committee specifically to talk on the transaction. This was almost like a second one.
And can you remember the date when that first Audit and Risk Committee meeting was?
It's sometime in September, I think maybe the 9th.
After the 10th, or even before the 10th?
I think before the 10th.
Oh, okay. And did you say you or the executives made presentations to, or a presentation to that meeting?
Correct, Chair.
Okay. Is that presentation different from what I thought was, I can see that's the presentation you talk about in paragraph 5.3. Is that right? Or at page 587.
Yes.
During the orientation of 24 July 2015, this GCEO mentioned that a big transaction concluded in April 2015 under the previous board was LSSA. I think somewhere in those lines you talk about doing a presentation.
Correct.
That's there. So was there a presentation to the Audit and Risk Committee and a presentation to the board, or only to the Audit and Risk Committee?
The presentation was to Audit and Risk Committee.
Or did you say on the 9th?
I suspect it would have been, but it was before the
Before
board.
the 10th?
Before the board of the 10th.
Oh, okay, all right. So well, it's another feature that seems to be similar to the ESCOM one, because in ESCOM 2, a new board, I think there were only 2 people, if not one, who had come from a previous board. A new board that wouldn't be expected to be very familiar even with the business of ESCOM and with the personalities who are in executive positions in their first full meeting, other than the induction on the 11th, made a decision to suspend executives, 4 executives. So here, from what you have said, there had only been one board meeting on the 10th, and there had been an Audit and Risk Committee meeting before the 10th, second Audit and Risk Committee meeting on the 22nd. They are talking about asking you to explain, isn't it? They are already talking about whether you should not be suspended. Is that correct?
It is correct, Chair.
Yes. Okay. Mr. Kennedy.
Thank you. Mr. Mhlontlo, in paragraph 5.6, you deal with the board meeting of the 10th of September. You did not notice any material concern on the side of the board. There were some questions noted and responded to in writing on the 14th of September 2015 in a memo. So were you alerted during the meeting, the board meeting of the 10th of September, that there were any concerns on the part of the board members or the members of the Audit and Risk Committee who form part of the board that there were any irregularities on your part concerning the LSSA deal that you were reporting back on?
Not at all. Not at all.
Now then you've taken the chair to the Audit and Risk Committee that happened on the 22nd of September, and you referred to a letter. Can I ask you in the bundle, please, to look at page 657? The letter, as we see from the last page at page 661, was addressed to you by Fikile Mhlontlo, the chairperson of the Audit and Risk Committee. Is that correct?
It is correct.
And it says in the text of the letter at the top on page 657, you're requested to provide reasons why the Audit and Risk Committee should not recommend to the board for your urgent suspension and disciplinary action to be taken against yourself. The Audit and Risk Committee held meetings as mandated by the board to consider what transpired during the board meeting of the 10th of September 2015, where information surfaced, amongst other things, that the Chief Executive Officer and the Chief Financial Officer misled the new board, the Minister of Public Enterprise, and the Minister of Finance, and further that PFMA and Denel MOI was contravened. Had any of that been said to you in the meeting on the 10th of September 2015?
None of this was said on the 10th of September board meeting. None at all.
Then it says in paragraph 2, it appeared that the reason given by yourself motivating for the board approval to allow you to conclude a sale of 49% or 50% of the DVS with an equity partner was false and fraudulent. Was that raised in the meeting of the 10th of September?
Beside the fact that that is statement in itself is incorrect, it was never raised at any point. The approval, PFMA approval by the minister requires that there be an equity partner to that extent.
And then paragraph 3, in the opinion of the Audit and Risk Committee, your conduct, actions, omissions in respect of the transaction between LSSA and Denel SOC Limited contravened the following legal requirements. Instruments. And then it sets out various requirements of the PFMA. And then paragraph 4 says the Audit and Risk Committee, after assessing what you've told...
I'm sorry, Mr. Kennedy. Just on a light note, 3.1 says Section 50 of the PFMA requires the accounting authorities of a public entity to exercise the duty of almost care. I think they meant utmost care.
Yes, indeed.
Yeah.
Fortunately, I'm not here to defend the chairperson of the Audit and Risk Committee's use of English or the typing.
Well, I guess maybe when you do things in too much of a rush, these things happen.
Indeed.
Yeah.
And then paragraph 4, Mr. Mhlontlo, the Audit and Risk Committee, after assessing what you have told the new board, documents submitted to the Minister of Finance and the Minister of Public Enterprise, it is clear that you did not act with fidelity, honesty, integrity, and in the best interest of the public entity in managing the financial affairs of the public entity. Now, and then there are various other allegations made against you. For example, in paragraph 8, you've contravened section 54(2)(c) of the PFMA by failure, refusal, or omitted to disclose the full and material financial aspects of the acquisition of LSSA by Denel to the Minister of Finance and the Minister of Public Enterprise. 9, you have, amongst other things, failed to comply with the conditions of approval from the Minister of Finance, etc. Now, Mr. Mhlontlo, this doesn't appear to have been said. These are the allegations, and we would like your comment on them. If we go back to paragraph 1, it appears to be a judgment that is made by the Audit and Risk Committee that you misled the new board and that you made false and fraudulent claims, paragraph 2, and in paragraph 3 it refers to an opinion that the Audit and Risk Committee had come to, that your conduct, actions, omissions contravened various legal instruments and the like. What did you understand the real purpose of this letter to be?
As I have articulated in earlier, before we got to this reference, that the initial point I made to the Audit and Risk Committee was there would be instances where the Audit and Risk Committee or any subcommittee of the board may not fully understand the rationale or the reasoning behind a particular decision. But it's expected that either at the board meeting or Audit and Risk Committee meeting to raise the issue with executives or raise the issue in between meetings, and the executives would then respond to issues at hand. I registered my not disappointment, but being taken aback by the fact that there is to suspension and beginning to impact the employer-employee relationship too early in the process was something that we were not expecting, and we were expecting to build a relationship with the board like we had a relationship with the previous board. Having a relationship is a business, is a relationship, constructive relationship. It's intended to take the business forward. So if we come to the point where they were intending to recommend to the board for our suspension pending an investigation, but also at the same time making a whole host of allegations, obviously something was amiss in that. Either you got issues, which is going to be, you're going to have a confirmatory investigation which wouldn't take that long, or you don't have issues. But we were in this difficult process.
Now, in your affidavit, you referred to concerns you raised with the Audit and Risk Committee about the process that was being followed, compared with the normal practice of discussions between different formal meetings. What does that relate to?
The concern I raised with the Audit Committee was the fact that...
Sorry, just hold on a moment, Mr. Mhlontlo.
The concern that I had with the Audit and Risk Committee was the direction the whole issue was about to take, and I could sense, and I was cautioning the Audit and Risk Committee to say, where there are issues that are not normally handled in this way. You would have to, you come in here, you are board members, over and above being Audit and Risk Committee. If you got issues, you should be able to channel your questions via the CEO. The executives have to respond to those questions. You would normally have special Audit and Risk Committee or special board meetings to deal with issues that the board, it doesn't fully appreciate. And my concern was where this was going, which eventually went the very direction that I was concerned about.
Did you then, or have you since, understand, or have you since understood what exactly you were being accused of in having misled the board, or having misled the Ministers of Finance and Public Enterprises, Nedbank and other stakeholders?
Chair, there were 11 months in which Denel had to demonstrate to me and my colleagues as to how we might have misled any party in the process. And as I indicated yesterday, there were 3 interactions where it was person to person, with myself included. Was a mediation in February, was a preliminary discussion in April. There was another preliminary discussion in July, which is 10 months down the line. And lastly, obviously, was the interaction relating to settlement. And we constantly stated that any aspect relating to this transaction we can answer.
Now, if you look again at page 661, which bears the name and apparently signature of Mpho Khomogwe, someone has written below that he did not sign the acknowledgement of the receipt of the letter, and he indicated that he needs to sleep over it, and he will respond tomorrow at the meeting at 1700 hours. Now, you've mentioned earlier that you were told you had 24 hours to respond. We can look at paragraph 19. It specifically says that you're invited to attend a board meeting scheduled for 1700 hours that next day, the 23rd of September, wherein you're further invited to present your reasons why the Audit and Risk Committee should not ask the board to suspend you. So you had about 24 hours to respond to the Audit and Risk Committee and also to make representations to the board itself why you should not be suspended. Is that correct?
That is correct.
Now, is that your handwriting at the bottom where it says he did not sign an acknowledgement of receipt of the letter? Or was that somebody else's?
I suspect it's Paul's handwriting, the Chair.
And is it correct that you would not sign to acknowledge receipt of the letter?
I was so taken aback by this letter that I had to reflect and think, what does it mean if I acknowledge receipt of this? And I thought, I wouldn't use the word irregular, but it was out of the ordinary. I had employee-employer relationship, and without any prior interaction to that it would have indicated any misgivings, to all of a sudden be given a letter like this. I apologized. I declined to sign it.
Did you respond during the Audit and Risk Committee meeting on the 22nd as to whether you felt that there was actually anything wrong with the LSSA transaction? That
meeting engagements were verbal, it was certainly not minuted, but I stated to the Audit and Risk Committee that there's nothing wrong with the transaction.
And after the meeting, after you were given a copy of this letter that you wouldn't sign for, did you then respond to the letter?
I think I would have covered it somewhere in my affidavit, point that we wrote a joint letter with Mr. Saluji, Miss Africa, and myself, that we broadly pointed out that there was no need for suspension. Suspension often arises under certain circumstances, and we felt that the issues at hand could be addressed. We asked that we be given more time. As much as the board, it might have taken 6 weeks to figure out this kind of letter. We would need more time, at least more than the 24 hours, to frame our responses. And also, it was quite clear that we would have to consult legally for some backing, because the direction in terms of where this was going was quite clear.
Now, what happened on the 23rd? Your affidavit refers to a meeting that you attended again with the Audit and Risk Committee before the board started. Is that correct?
Yes, on the 23rd, there was a meeting at 1700 with the Audit and Risk Committee, which we had already, an hour or so before that, we had sent our broad response. And the Audit and Risk Committee was pointing out that it's a pity that they gave us an opportunity to respond to these allegations. And because we have not responded, it would proceed to engage with the board to make the recommendation that we be suspended. On that day, later on, the members of the board, some of the members of the board joined the meeting. We were called into the meeting one by one. We were told that the Audit and Risk, we were given an opportunity by Audit and Risk Committee in which we have not responded, and therefore we would be suspended. But interestingly, that there is a document that got served in that session that had already or was already appointing who would act in my position, framing a little bit of background of the individual, and already framing who would be acting in the position of the CEO, tabulating how many years he had been with the company, etc., etc. And last point is the fact that the individual who would be acting as a CEO was in the building, this went on into the night. We were effectively suspended around 10. The individual was in the building, and when he joined us at some stage, because we were sitting outside the board meeting, he stated that we asked why he was hanging around. He said, no, he's hanging around because the chair had told him that there would be a big announcement.
Who are you referring to there?
Zwelaki.
Zwelaki?
It was Zwelaki and Mr. Zwelaki and Tsepe.
Tsepe. And was he then in fact appointed as acting Group Chief Executive Officer when Mr. Saluji was then suspended?
Yes.
And who were you replaced by in an acting capacity as Group's Chief Financial Officer?
Mr. Odwa Mhlwana.
I just want to take you back. You said that the Audit and Risk Committee said it was a pity that you'd not responded with reasons why you should not be suspended. Had you given reasons why you should not be suspended? And if not, why not?
We were seeking to extend the grace period we had been provided, which we were given 24 hours. We said, look, you certainly took 6 weeks in which to frame and put forward all of these issues. We are asking you to afford us 5 days in which we would think through a response. Certainly where we sit, to the extent that the responses are all can be a verbal engagement with the board, we are quite happy to do so. But if we are going to comprehensively respond to all the points that you're making, we need a bit of time. And we went on to point out that there isn't a need for a suspension. We felt it was premature.
So on the 23rd, you had this meeting with the Audit and Risk Committee. You referred to that being followed by the full board meeting, correct?
I'm not certain that all the members of the board joined, but certainly a majority of the members of the board joined.
It was a meeting of the board as distinct from the Audit and Risk Committee that had already met separately?
I would sum it that way.
And were you suspended at the end of that meeting?
Yes.
Now I'd like to take you please in the bundle to page 677. This is a letter from the attorney Zarina Walele, page 677. And it appears that Ms. Walele was acting as your attorney as well as that of Mr. Saluji and Ms. Africa.
Correct.
Is that correct? What was the purpose of this letter? It was sent on the 25th of September, is that right?
It is.
And what was the purpose of this letter?
The way I read the letter is that by and large he is asking for a fair and a reasonable opportunity. I suppose.
Yes, can I take you to paragraph 3 then? Is that what you're
I'm actually looking at the paragraph 3, yes.
Yes, so they requested, that's yourselves, a fair and reasonable opportunity to do this, to make representations, including a brief extension until the 30th of September 2015, also taking into account that the 24th of September was a public holiday and that they're entitled to seek legal advice and be represented per the MOI. And then it refers to the attitude of the Audit and Risk Committee. And then there's a complaint in paragraph 5 about you're having a fundamental problem with the logic and fairness of the attack on their credibility and procedural rights, and then it sets out reasons. And then it refers to paragraph 68, page 680, paragraph 8. Regrettably, in all the circumstances, our clients are compelled to come to the conclusion that neither the A&R committee nor the board members present at their suspension have any interest in observing procedural fairness or learning the objective facts and accepting the principle of innocence until proven guilty. Did that reflect your opinion at the time?
Precisely. Thank you. Yeah, it is.
Have you changed your opinion as you sit now? Is that still your opinion?
It's many years since this happened. I have moved on. It's a pity I've had to go through this process. And it's behind me.
Then in paragraph 9, your attorney says on your behalf, going forward, in the motivation for suspension, the A&R committee indicates that legal counsel will be further engaged to complete the investigation. 9.1, given that the committee and the board clearly seek our client's dismissal and clearly have already drawn their own conclusions and have, quite apart from the untested merits of the matter, concluded that there is already a breakdown of trust which our clients deny, they too intend being legally represented at the disciplinary inquiry and welcome the expeditious finalization of the matter. I just want to dwell for a moment on the assertion by your attorney that it appeared that the Audit and Risk Committee and the board had already made up their minds that you were guilty and should go, or that the relationship of trust had already been broken. This was before any disciplinary inquiry had been started, is that right?
It was.
And is it correct that you did in fact then get legal representation not only through your attorney, Ms. Walele, but she briefed on your behalf Senior Counsel, Mr. Craig Watt-Pringle, is that correct?
Correct.
Right. And then she refers, paragraph 10, to a letter dated the 23rd of September in which you'd already proposed, it's referred to elsewhere in your affidavit, Mr. Mhlontlo, where you'd already proposed final and binding arbitration in terms of section 188A of the LRA, since they're confident that there's no merit to the allegations. Now, just to indicate for the benefit of lay people who may not know, section 188A of the LRA is a process in terms of which the CCMA can appoint an independent arbitrator to conduct a disciplinary inquiry rather than an employer conducting its own internal inquiry. Is this what you were requesting?
Yes, correct.
And why had you proposed that this process should be conducted through an independent arbitrator?
This arose because of the way everything had unfolded, and it kind of gave the impression that there is a foregone conclusion somewhere to get rid of us. If one takes into account that we were given sort of 24 hours to respond, given that our plea for what we deemed as a reasonable time to respond was not accepted, given that we were then suspended, but just before we were suspended, we were given an option to take 3 months package. It was quite clear that the process, it may not be as fair.
Then your attorney continues, still in paragraph 10, such a process will also test the bona fides of the charges and the board's willingness to expedite the matter. It is not appropriate to take a further 90 days to investigate. We request that you consent to the following, and then your attorney makes a request, for example, that a final charge sheet be sent to you by no later than the 2nd of October. And then there is a request for appropriate presentation time. 10.4 requests that independent senior counsel be, who's an expert in employment law matters, be appointed to chair. And then there's reference to section 188A again. Was the investigation by Denel Was it in fact completed within the 90 days?
I'm not certain. All we are aware of, or what happened was, the updated charge sheet was sent to us on the 18th of December. Whether that was informed by investigation or not, we aren't uncertain. But also, as I alluded to yesterday, the meeting of the 22nd of April 2016 sort of in the bundle included a letter that suggested that by the 17th at least, the investigation was not concluded, and that investigation had been undertaken by Denton law firm.
And you were in fact contacted by Denton's, you say in your affidavit, during the course of their investigation. Is that correct?
That's correct.
Right. Now, if I can ask you to turn to page 686, this is a further letter from your attorney, Ms. Walele, dated the 1st of October.
Did you say 686?
Yes, Chair.
Okay.
And I'm not going to go through all of the contents. It can be read for its own contents. It indicates inter alia that you challenged the lawfulness and fairness and the necessity of a suspension. Is that correct?
That's correct.
And it also indicated that your procedural rights had been violated. Is that correct?
That's correct.
And it also asked for a response to the earlier letter, the 25th of September, that we just looked at earlier in some detail, to which there had not yet been a response. Did you cooperate with the Denton's investigative team?
We cooperated fully.
Now, I'd like you please to go to page 663, earlier in the bundle. That appears to be a letter issued on the 18th of December 2015 and apparently signed by Mr. Mancha, who at that stage was the chairperson of Denel. If you see on page 668, his name is typed in and what appears to be his signature appears. Did you receive this letter?
Yes, we did.
And is this effectively a charge sheet?
It's effectively a charge sheet, yes.
I think I didn't hear the page correctly, Mr. Kennedy.
It starts at page 663.
663.
Yes,
Okay.
Chair.
Thank you.
And the signature appears on page 668.
Okay.
Was there any explanation given to you that despite your attorney's request that the charges be finalized within a brief period and the investigation be finalized within a brief period, why only 3 months later, approximately 2.5 months later, on the 18th of December, were you given this charge sheet?
There was no explanation. In fact, it's almost close to 3 months, given that we were suspended on the 23rd. It's almost like 3 days before or 4 days before it's 3 months.
Now, you've referred in your affidavit and you've given evidence yesterday also about requests for documents from Denel. What documents were you or your legal team requesting from Denel for purposes of preparing for the disciplinary inquiry?
The normal process would be a bundle of evidence comprising of this letter cross-referenced to various documents that the employer is relying on to make their case. and which is the standard in the sort of employer-employee sort of disputes or disciplinary processes.
If you look at page 667, paragraph 4, indicates that Denel views the allegations very seriously, and because they are so serious, if you are to be found guilty at the disciplinary inquiry, Denel will request that strong action be taken against you, which may include dismissal. So you were aware, were you, Mr. Mhlontlo, that this was of a serious nature and could lead to your dismissal?
Yes, I was.
May I just ask, apart from your dismissal, if you were found guilty of the charges that you had misled the board and you had misled 2 ministers of the National Cabinet and you had misled National Treasury and other entities, if you've been found guilty of those offences, apart from justifying your dismissal from Denel, would that have had any consequences for your future?
As I stated yesterday, I am a CA. For the longest of time, I was in practice as an accountant. So, assuming the legal processes maybe don't really end up anywhere, the very least I would lose my CA membership, and it would impact my career. So it was important, and we insisted along all the way that Denel must prove its case. It was critical and important for us to go through the process.
Now, you mentioned yesterday also that what then happened was that instead of the disciplinary process starting at an early stage, there was a mediation process. Correct?
That's correct. There was a mediation process on the 8th of February.
Can I take you to page 691, please? This is a document headed "Points to be raised by executives during the mediation of 8th February 2016. Is this a document that you and your colleagues, Mr. Saluji and Ms. Africa, prepared?
Yeah, correct, Chair.
And what was the purpose of this document?
It was sort of a document that was guiding us in terms of what points we wanted to put across to the mediator, which we understood the mediator would be engaging us and the representatives of the board. So these are the points that we went through.
Now, did you actually table this at the mediation?
We did not table it, but we read this at the mediation.
I'm sorry, just speak up a bit, please.
We read
it out?
Yeah, we read it out, yeah.
And the mediation was chaired by outside senior counsel, is that right?
Yes, correct.
Right. Now, I'm not going to go through the detail, but on page 694, you set out a conclusion, and your paragraph 20 reads, "From our perspective, the issues before us are therefore not about what we ostensibly have or have not done, but rather what the intention and actions of this new board have been." What do you mean by that? Denel have raised what appear to be serious allegations of misconduct, including effectively misrepresenting things to the board and to ministers and National Treasury and the like. These were serious allegations. Why were you saying this doesn't really seem to actually have to deal with what we ostensibly have or have not done, but rather the intention and action of the new board? What did you mean by that?
The concern that we had was the new board that had come in, the new board that in being in office roughly 6 weeks or so had summarized what we had presented to them as management in the normal course into what we would term it maybe more prima facie case, And it was very clear and communicated to us all the way that the intent is that we must exit the business. On day one of the meeting, which was more of a board meeting, that intent was made very clear. At the meeting of around the 19th of January, where our attorney met with the attorney of the employer and met with the Advocate Kasim, who was to chair the disciplinary, and in a preparatory process, the representative of the employer made it very clear that the outcome they are wishing to achieve is that we must exit. So it was quite clear. So that point talks to how the process had happened and what we were reading to be the intent of the board.
Now, the clear intent on the part of the board that you should exit, that was stated before the disciplinary inquiry had been started, let alone finished. Is that right?
But before there was even a suspension itself, the fact that we have an option to accept, resign and take 3 months was made clear. In the interactions between our attorneys and the attorneys of the employer, that point was made clear. So hence we make this particular point.
Do you believe, was your impression and belief from how you were treated, that the board were genuinely concerned that you had committed misconduct by misleading the board, or are you suggesting that there was some other hidden motive?
In our view, is that charges were written. It didn't really matter whether there was substance behind those charges or not to achieve a specific outcome.
Was there substance to the charges, Mr. Mhlontlo?
We will deal with them in my affidavit, and we continue to maintain that there is no basis for the charges. There was no basis back then, to continue to be the case.
You then, in your statement for purposes of the mediation at page 694, you deal in paragraph 21 with your desire that the shareholder, the new Minister of Public Enterprises, be transparent and accountable for what has happened in Denel after her appointment to the new board. Which minister was that?
It was Minister Lynn Brown.
And why were you making this point?
There had been a press coverage before this time, where the minister had gone to press and said she had not been briefed as to our suspension. So that, hence we're making this particular point.
Then you say in paragraphs 22 and 23, we are of the clear and unequivocal view that we were unfairly suspended. We want in no uncertain terms to be reinstated, and for a public apology to be made that acknowledges our innocence, our integrity, and our commitment to Denel. We are ready and prepared to pursue the process to its logical conclusion. We want to reiterate that we are committed employees of Denel. We have always conducted ourselves with integrity and in the best interest of Denel, its employees, SANDF, and our country. When you said here, Mr. Mhlontlo, that we are ready and prepared to pursue the process to its logical conclusion, what were you meaning there? Was that the disciplinary process?
In the employer-employee disputes or issues, the starting point is a disciplinary process. So in our view, is that we were going to go through a disciplinary process. So mediation was one aspect of it. In the event that mediation is not successful, obviously we must go into a disciplinary. But we went into mediation with one clear outcome we would wanted to achieve, was to mediate so that we go back to work. If it's not mediating and it's not successful, then we go to disciplinary. We're happy to subject ourselves to the process.
Now, your affidavit then deals, I'm not going to go into detail, Chair, but your affidavit deals with the process that followed that mediation session the mediation did not produce any outcome in the sense of any agreement or resolution. Is that right?
Correct.
And what followed then was a series of correspondence that is referred to in your affidavit, dealing with repeated requests for documents and the convening of the disciplinary hearing. Ultimately, I understand that the disciplinary hearing was to be chaired by Mr. Tererai Rector Mafukidze. Is that right?
Correct.
And then, if I can take you to page 711. That is a ruling from the chair, Mr. Mafukidze, correct? In fact, his ruling indicates that it's dated the 12th of July. Sorry, it's dated the 13th of July, but relates to a hearing on the 12th of July. But it also indicates in paragraph 1 at page 711 that there was an initial hearing on the 22nd of April which dealt with a preliminary issue which was argued by both sides' counsel. Is that right?
Correct.
And it related to the production of documents requested by you from the employer. Is that correct?
Correct.
So as at April 2016, you or your attorneys were still asking for documents from Denel.
Correct.
Am I correct in understanding that you were now facing a disciplinary hearing separate from that for Mr. Saluji and Ms. Africa?
Correct.
Right. And then the chairperson, Mr. Fakudize, says in paragraph 1 to 3, Mafukidze, sorry, he says that he made the following ruling after the hearing of the 22nd of April. Put to the page, within 7 business days of this ruling, the employer shall produce copies of the following documents. And then he sets out the various documents that have to be provided, which included reference to the Denton report. In relation to that, in paragraph 14, he made the following ruling. So far as the Denton's report is concerned, Mr. Barner, is that senior counsel for Denel, who was involved in the disciplinary?
Yes.
He stated on record that the report was not the basis of the charges and therefore was irrelevant. He further stated that the report was not yet ready. The employee was interviewed by Denton's and gave whatever information he had to give. I do not think that the report's relevance has been proven. It is speculative that it would serve as evidence of the employee's innocence. The employer can only be ordered to make available such documents as are relevant and in its possession. So he ruled that the employer should provide some documents that you'd requested, but the Denton's report, he was not satisfied that it needed to be provided. Is that correct?
That's correct.
At this stage of this ruling, Mr. Mhlontlo, you had not come into possession of the letter from the chairperson of the board to the company secretary instructing her to get Denton's to substantiate the charges. That had not happened yet.
That had not happened as yet.
Okay. Yes, Mr. Kennedy.
Now, these documents that were ordered to be produced by the employer, did they get supplied to you?
The reason why the session on the 18th of July couldn't really get far is because those documents were not in place. There were reams and reams of some documents, but they were not coherent. They did not make sense. They were not part of pulling the file together to substantiate the charges. So on the 22nd, given that those documents had been requested way back, we're not in place on the 22nd. We're not in place by the 18th of July.
Now, if I can take you to page 715, there's discussion in paragraph 23 about whether the hearing could proceed, and your reliance on an alleged right to be consulted before the dates are set. You referred to the fact that your counsel was available on particular dates, but the attorney was unavailable on some dates, etc. So was there in fact an argument about whether the hearing should be proceed on the merits of the disciplinary charges?
There was no, on our side, we always wanted the disciplinary to take place timelessly. We always insisted that before the process itself, there's got to be a bundle of documents so that we can prepare ourselves. And certainly the first date that was set was that of 25th of January 2016. The session couldn't sit because there were no documents provided, there was no file, and because there were no documents, there were no files. The discussion between the attorneys was that maybe let's just maybe find a mediation, which could be an easier process. Went through a mediation that did not yield anything. They now changed its strategy and wanted to question me on the validity of my contract sometime in March, and being pointed out that that is not their competence. It then moved into the 22nd of July. So this point about agreeing dates, it is important because this thing was just not coming to an end. And the professionals that were assisting me, they had their own diaries to manage.
Chair, I've noticed that the copy that the witness has attached to his affidavit of this ruling document, only if you look at the typed page numbers at the foot of the page, jumps from 1 to 3, 3 to 5, etc. It appears that the evenly numbered pages have been missed out in the photocopying process. Maybe ask
Yes, I see there is no page 10.
Yes, in fact, it looks like all of the even numbered pages are missing.
Yes.
If we can undertake with the assistance of the witness, or if necessary from Denel or their attorneys, to obtain a complete copy and then have a supplementary affidavit signed by Mr. Mhlontlo, just to correct that. That can be done.
Yes, no, that's fine. That should be done.
Thank you, Chair.
I think your team must just check whether there are any other documents which suffer from the same defects,
Yes.
so that they can be identified and corrected as well.
That will be done, Chair.
Yeah.
Thank you. Mr. Mhlontlo, the end of the ruling at page 719 sets out the decision of Mr. Mafukidze, the chairperson. His ruling on the Denton report remained unchanged. The hearing was set down then for that was set down for the original dates in July was postponed. He refers to the parties being expected to try and agree fresh hearing dates for the disciplinary hearing. And if there couldn't be agreement, the employer could then set down the date in consultation with the chair to ensure his availability. And then it refers to you providing the bundle of your documents as well. Now, ultimately, the disciplinary hearing, as you told the chair yesterday, still didn't take place ever. Is that right?
The disciplinary, as a proper disciplinary, never took place. On the 18th, we still argued about documents. We still argued about bundle of documents.
Yeah.
We argued about the point that there is nowhere where the employer is proving guilt, and the meeting was then postponed to the 3rd of August 2016, which was the date of the local government elections, and it never, I suppose I would have struggled to vote if I had a disciplinary on that day, but never got there.
Now, your affidavit refers to your having received some documents at the hearing in April 2015 when Denel had given a lever arch file with some documents which included a particular document that you refer to and then attach to your affidavit at page 721. Now, this is a letter. You have 721?
Yes.
This is a letter, it appears, from Mr. Mancha, the chairperson of the board, on the 17th of December 2015, where addressed to Ms. Lechwaba, is it, the acting company secretary?
Yes.
And the chairperson requests her, was she the person who replaced in an acting capacity Ms. Africa?
Correct.
And he requests her in paragraph 1 to furnish us with a draft charge sheet so that we can settle, as we need to have the charges served upon the suspended employees before close of business tomorrow, the 18th of December. We've already seen the charge sheet that was in fact served on you on the 18th of December, correct?
Correct.
Right, then he says, and in paragraph 2, and further request you to instruct our lawyers to draft a settlement proposal of 3 months' payment in full and final to the 3 suspended employees. The letter for settlement must be delivered tomorrow with the charge sheet and further with a letter informing them that their suspension is extended until the finalization of the hearing. Now, you have mentioned in your affidavit that when you picked up this letter that appeared in documents provided by management's representatives in April, you found it significant that there was mention not only of the charge sheet but also the settlement proposal. What significance do you attach to that fact, Mr. Mhlontlo?
It's always a little bit of a mystery that you write charges that are so big and have serious ramifications, and at the same time you put a caveat that says, we are quite keen to settle. That's one point. But this letter, rightly or wrongly, the paragraph 4 of this letter will read maybe more fairly obvious, maybe a hidden meaning, because that particular paragraph in our reading, it means that there was an element of eagerness to have the process in that report reading in a certain way.
If we can read into the record, paragraph 4 says to the company secretary, "You are further requested to inform Dentons that their report is not accepted and request them to provide us with a report within 30 days and kindly direct them to provide information to support the charges. Lastly, may you recall the circulated Denton's report and make sure it is not circulated." Did you ever see the Denton's report that is referred to?
We never saw it. We were told it's never ready until the very end of a long process.
And what did you see ultimately? Was that the original Denton's report that appears to have been retracted and had to be rewritten?
Our reading of the letter is that there was a version of a Denton's report that was not to the satisfaction or was not in line with what the board had anticipated it would be, and they were asking for it to be retracted. But also the line that says, kindly direct them to provide information to support the charges. It sounds a little bit suggesting that there was a little bit of massaging in terms of what direction they should take in terms of preparing the report. And then again, it fed to the speculation that we were being sort of elbowed out.
Mr. Mhlontlo, I want to just read out a sentence from your affidavit. You don't need to go to it, but for the chair's purpose, if you need it, Chair, it's at page 592, paragraph 5.28. And you there comment on the settlement proposal that the chairperson has asked the company secretary to prepare, page 592.
You said 592.
Yes, Chair. Page 592, paragraph 5.28. You say the chairperson goes on to require the acting company secretary to instruct our lawyers to draft a settlement proposal of 3 months' payment in full and final settlement to the 3 suspended employees. Of course, we know from your evidence yesterday that ultimately they offered and you accepted 24 months' salary plus an incentive bonus. In addition to the fact that you'd been on suspension for about a year. What I'm interested in is your next statement, Mr. Mhlontlo. What is quite remarkable about this is that the charges against us were stated in serious terms, including reference to dishonesty and gross negligence. Then why Denel would in those circumstances seek to settle the matter is beyond comprehension. Now, the chairperson has already asked you to an extent about this aspect. I would just like you to comment particularly about why you were driven to say this in your affidavit.
As I really have pointed out, is that we sit with this particular history, we sit with charges that were alleged that we were done, and then every time the charges are laid out, there was always one caveat that says we're quite happy to give you some rands and cents so that you disappear. So if these charges were ever real, why was that the case?
Chair? Yes, would this be a convenient time, Chair?
Yes, I think
Thank
so.
you.
Let's take the tea adjournment. We'll resume at 11:30. We
Please,
adjourn.
Chair.
All rise.
Okay, let's continue.
Thank you, Chairperson. Mr. Mhlontlo, we can wrap up this section of your evidence. If you can turn to page 593. Your affidavit then refers to the disciplinary hearing that was held on the 18th of July, but there again it dealt with preliminary issues concerning documents, etc. Is that right?
It is correct, Chair.
And then you say in 532 that Denel was still not ready to prosecute you on the charges, and so then the matter was postponed again to the 3rd of August.
Correct.
And then you refer in 534 to what you mentioned yesterday in evidence before the Chair, that you were contacted by the acting CFO, the group's CFO, the person who was acting in your position, Odwa Mshluwana, who said he had a mandate, and you ultimately, in the lunchtime meeting, discussed the settlement that he proposed, and you ultimately settled. May I ask, did he come with the 24 months plus the incentive bonus as his mandate, or did you have a negotiation back and forth where he started, for example, at 6 months and you pushed him up to 24 months?
The first meeting at the Baron in Woodmead, he indicated that he had a mandate. He ascertained the period which was left, or wanted to clarify the period that was left within my contract, and he asked to what extent I would be amenable if he's seeking some settlement within the context of the number of months that were still left. Roughly at the time was about 30 months, whereas I think at some stage what was left in my contract obviously was far longer than that, but because of the period I had been at home, the period obviously had reduced, and I indicated my amenability to engage and to find a solution. But whatever Denel had presented to me up until that point was not acceptable. Whether we're talking about the 3 months, in some sessions, 3 months features a lot in these documents, but there were indications that the months could be 8. At some point, it became clear that could be 13, which I had stated to Denel that was not acceptable. So he then went away. A week later or so, he called me. We met at Midrand. At that stage, that's where we had any in principle settlement that the 24 months would be okay. I would forego roughly 6 months or so, and he said you would then engage on that with the principals, and few days, maybe a day or so later, he gave me a call to say that okay, we can proceed on the basis in which we had discussed. That got reduced into the settlement agreement.
Chair, if I may now turn to deal with other issues, and specifically those raised in the initial affidavit. The first, in fact, it's a statement that you find from page 568. Chair, there are a number of sections where the witness has indicated in his affidavit that he had little, if any, involvement in anything. So that obviously arises from questions raised by the investigators. Just for the sake of completeness, I'll touch on the ones that may be of some interest, but very, very briefly, if I may.
Yeah, that's fine.
Just before we get into the meat of the specific transactions, Mr. Mhlontlo, you set out your professional background from page 569, which you touched on yesterday, but I just want to fill in a couple of gaps. You have a BCom in accounting degree and an honours in accounting, is that right?
That's correct.
And then you joined the firm EY, used to be known as Ernst & Young, and you got accredited as a chartered accountant in 2001, And is it correct you were a partner, you say, in 2.6 in one of the big four accounting firms? Is that EY? Did you attain partnership status in that firm?
Correct.
And you then joined Denel in October 2008 as Group Financial Director, and you became a member of the Denel main board of directors.
Correct.
Until the time of your resignation. Now you then deal in paragraph 3 with the process followed by DLS. It's the Denel entity when awarding the Tarrant Hulls contract to LMT. Now you've corrected in paragraph 3.4 already yesterday the date from April 2009 to April 2010. As I understand it, you had no real involvement in the award of this contract by DLS to LMT. Is that correct?
That is indeed correct.
Thank you. Now, you were then asked to comment on the procedures that Denel followed in relation to the advance payments, and in particular the 12.7 million rand that was advanced to LMT. You've mentioned in your affidavit that it is normal practice to make advance payments in some circumstances in the defence industry to suppliers. As I understand it, you were not involved in the actual process of approving any advance payments to LMT. Is that correct?
There is one element that we'll deal with that talks to that email of April 2010, but in terms of advance payments of any kind, certainly I was not involved in.
Yes, you mentioned in paragraph 4.4 that you attended a meeting where the advance to LMT was mentioned, but there were discussions that this fell within DLS management ambit.
Correct.
Now, what I'm interested in is your paragraph 4.5, the foot of page 572. I understood the advance payment to 12.7 million by DLS management, supported by the board, was to start production, which is a normal practice in the defence industry. The forensic investigators have, however, presented evidence that contradicts this understanding. Presented to me an email correspondence between DLS officials and management of LMT suggesting that the advance payment was made by DLS mainly to assist LMT alleviate financial problems that were faced by the company at the time. But then DLS management will need to account for the contradiction. The Chair has already heard evidence in relation to this advance payment. To the extent that the evidence indicates that, in fact, this was not a normal course advance payment to a supplier in the normal course, but in fact was to assist LMT in its financial difficulties. From your perspective as at one stage the group CFO, can you comment on whether that was acceptable from a group financing point of view?
If we go back to 4.4, it makes reference to a meeting that took place in April 2010. It further points out that there was a discussion, which I then followed that by an email. Yesterday, as Mr. Piet Nutze was addressing you, Chair, this email was covered in detail, where I expressed the concern that if you are to order this turret hull from LMT, but in the same vein, you are stating that LMT is in financial difficulties, it presents a risk to the group. Tread carefully, considering that this is a public institution, and if you really feel within yourself that you really have to do it, make sure that guarantees are in place so that in the event that LMT has any financial difficulties and is unable to operate, you are able to extract the value or the assets or recover the money. I never preempted that we would have this hearing today. But the level of seriousness that I took that advance payment, and it shows that there was a sort of care on my side and over the resources that we were given an opportunity to be a custodian of at the time. And that position, and Mr. Nutse goes on to say, a month later, I might have changed my mind without providing any evidence that substantiates that position. And even if we were to go to those minutes of that meeting, certainly the questions I had posed was to what extent they had started to implement my email. And there were certain responses. But there is nowhere where I communicate that I was miraculously satisfied that they had done all the things that they needed to do. Given the quantum involved, which is 12.7 million, it was their responsibility. They have to answer from here whether they put in place all the things that I thought were bare minimum that were required in that.
Now you then proceed from page 573 to deal with your response to questions about the procedures followed when Denel was acquiring LMT and how Pomotsi ended up being a BEE partner. Were you involved in the transactions that led to the acquisition of LMT?
Before, Chair, I respond to this question. There's another aspect that's linked to that 12.7 million. The 12.7 million, as per my email, was an advance payment towards a product that was bought from LMT. The evidence yesterday indicates that even though it started that way, it then changed form into something else. I was not party. I cannot recollect. I can't remember being party of something that I was so concerned with, and to the extent that I documented it in that fashion, when it changed the format to be that of financial assistance. If it's proven at some point that I was party to it, I would have made a mistake, because Denel is not a bank to advance monies in order for some other companies to escape failing.
Now, at page 574, paragraph 5.6, you refer again to the advance payment of LMT, which reflected as an asset in the Denel Group, amounting to 12.7 million and was converted to equity sometime in 2013, alongside Pomotsi's loan to the LMT business. Conversion had a neutral financial impact to the business, as advance payment asset was merely converted to an investment asset in the books of Denel. Are you saying there that you feel, from what you've been able to pick up from the information, that the 12.7 million rand was properly accounted for as the so-called advance payment to LMT?
From an accounting viewpoint, when that money left the group as an advance payment, is reflected as an asset. It's not expensed. It's reflected as here's a value of something that we hold. A couple of, maybe 2 years or 2.5 later, the proposal that amount must now be converted to equity, it simply changes the form. Instead of being described as stock or work in progress, it's now described as an investment in LMT. There is no loss in the company, there's no loss in the fiscus. But the issue that is presented to me by the investigators is there are underlying agreements or reasons that other than what was presented to me, and that in itself is a problem.
Is there anything you want to add in relation to the process followed in terms of which Denel purchased the majority shareholding of LMT? Any comment as to whether it was regular or irregular in your view?
There was a genuine, at least based on the facts that were presented, there was, and would be the central message within the PFMA application, that there was a capability that resided within LMT that was required by Denel. If we go back to Mr. Mkhwanazi's testimony yesterday, he also stated that even way back to 2002, there was a view that there's capability sitting in Denel, LMT, and I think there was another third company. So there was a presentation by DLS that here's a company that has got a capability that complements our capability. And if it were to cut, there is a position that has been sort of put out there that Denel could take this company at zero cost, and it would enhance its ability to mitigate any risks that are likely to be there on who face them. And so that acquisition as a process, my concern as a CFO at the time was that if you bring on board a company with financial difficulties, sometimes there are other issues, and reputationally there could be other liabilities that are not as clear. Perhaps what we should be doing sort of an asset stripping of sorts, and you could look at taking the employees and buying the plant that you require for the purpose. Of course, that was not the view that won the day, and as a part of that exco, I align with what prevailed at the end.
Now, of course, you ultimately resigned some years ago from Denel in the circumstances you've described to the chair. By the time that you left as Group Chief Financial Officer, did you have a view and an understanding of whether the LMT acquisition was good or bad for the Denel Group, particularly from a financial perspective?
At the time, it wasn't so clear. They had secured a huge order from overseas, and they had received an advance payment. It seemed as if the future of that business would go in the direction that had been presented as part of appraising and motivating for it. It had some challenges in the short term, though.
And from the process in which the investigators have put certain things to you and asked to comment on processes and so forth, do you have any different view now as to whether LMT was a good thing or a bad thing from a Denel point of view, financially?
It probably wasn't a good decision. There were certain assumptions that were made, and one of the assumptions was that Denel's order book at the time was growing. LMT's order book had a history of growing, but had started declining. They had the capability. They were not a big business. Given our growth as a company, they would then complement what we were doing. They would become subcontractor to a number of our programs. If you now look at it where Denel is at currently, where the order book is dwindling, and it certainly hasn't worked out as the way it was envisaged.
Right, thank you. I'd like to move away from the LMT acquisition and the advance payment. Chair, if I may refer the witness to his second statement, which is in fact an affidavit from page 576. You would turn to that, please, Mr. Mhlontlo.
Yeah, no, that's fine. Before you do so, I just want to ask this question because I don't want to forget it. At the time of your suspension, are you able to tell me what Denel's financial situation looked like?
Yes, Chair, I'll answer just now.
I'll be happy if you can tell me that, because we hear what Denel's situation is now, and I had evidence from Ms. van Rensburg, who was the chairperson of the board that was before the board that came in 2015, before the board that was chaired by Mr. Mancha. My recollection is that she said at that time when her board, its term ended, they had a plan to take Denel to higher heights, and everything was looking very good, and so on and so on. But you might be able to give me your own understanding of what Denel's situation was when, at the time, you were suspended.
Chair, Denel in the financial year ended March 2014 posted revenue at 4.5 billion with a operating profit of 282 million. That is 2014.
That's the 2013-2014 financial year.
2013-14, yeah.
Yes.
If we look at the year 2015-2014, they posted a 399 million.
So that was going higher.
Then in 2016, it posted a number of 605 million. Or 505 million. 605 million. Now, this is a company that had a history of significantly underperforming. Came 1992, let's say prior to 1992, had a captive market, which was the South African government, and with its own projects and programs, and industry survived at the back of that. After 1992, Cold War, no one is fighting with no one, I suppose. And then the business really struggles a lot, and a number of CEOs were appointed, a number of turnaround strategies were put together, and those strategies evolved from being a decentralized business into a centralized business, evolved from introducing equity to be 100% owned businesses in different fields. It streamlined, got rid of, it had businesses even that was producing soya beans and breakfast cereals, and it did some plastic molding. It was in IT, it was in everything. They went through a process of getting rid of those businesses, streamline itself, in certain strategic businesses, bring on board equity partners. And there was retrenchments, obviously part of the game to ensure a profitable enterprise. We're beginning to see those results coming through. The cash at the bank was becoming slightly bigger. We're enjoying a sound and a very strong relationship with financial institutions. Every year, we would go and meet no less than 20 financial institutions that were supporting this company. But if I then look at the numbers beyond that, if I look at 2017, it's more like a break even. If I look at the year 2018, it's a loss of about 1 billion. If I look at
2018, a loss of about?
2018, a loss of about 1 billion. And then if I look at 2019, the loss of close to 2 billion.
So from 2017, 2018 financial year,
then
it started going down. Okay, thank you. Mr. Kennedy?
Thank you, Chair.
But it looks like when it started going down, it went down quite sharply.
Indeed.
Yeah. Okay.
Thank you, Chair. May I then ask the witness to now refer to page 577. This is in your second statement or affidavit, Mr. Mhlontlo. Now, this deals with the award of the contract to VR Laser for platform hulls. Now, you've set out in some detail what was initially proposed to you, which was that there should be an award to VR Laser, and it appears that initially you had doubts about that. Could you tell the chairperson how this came about, how you became aware that this was the intention, and what your attitude was?
In around June, maybe July, the CEO of DLS, which is the Denel System, wrote a memorandum.
Is that Mr. Berger?
Mr. Berger wrote a memorandum in which the memorandum summarizes a process that they had followed to put out the HAL tender, and it spelled out that 3 companies had tendered for that, which is LMT, ECD, and lastly VR Laser. The memo criticizes extensively the quality and capability of LMT, appraises the quality of VR Laser, and the numbers were tabulated in there that the VR Laser is offering 260 or thereabout million. The lowest tender, I think, was about 161 or thereabout from LMT, and in between was the DCD. And the recommendation was that they wished to place the order with VR Laser. I rejected that strongly. There's no matter to what extent technically and the quality being good, it cannot be acceptable in my view, where the price difference between the second at least was like some between 80 and 100 million almost. And I opposed that, I rejected that. It further, that position was seconded or supported by the group COO, Mr. Jan Wessels, who also was on the same page as me on that. Because at that point we then became privy to that process, and LMT being an internal group company, we specifically requested that there be a meeting between ourselves, which is Mr. Jan Wessels, myself, Mr. Berger, and Mr. Nel. Even though we had no intention of saying, this is not about to be awarded to you or not, but because they had raised a number of technical concerns, we wanted to understand, what are there in reality technical issues, and also if they are, to what extent those can be mitigated, whether it would mean that DLS, how DLS can support the process so that the technical issues could fade or go away. My concern from a finance standpoint is that if you award the business externally, you are depriving the group the money because you could evolve the money within. The debate in there was a very strong emphasis by DLS that technical issues are so material that it would risk the entire Hoefester project if eventually it would be placed within LMT. They went on to show letters. There was one letter from UN about the work that LMT had done and it had issues. So it became a big issue. there were a number of options that were put in there. What about if you award the work to LMT, but LMT subcontracts some aspects to VR Laser, of which LMT was not amenable on that option. And I recall writing an email to Mr. Dr. Nell to the effect that any money, whether it's a small money, because his argument was that that model wouldn't really ensure a good profitability for his business. And I then pointed out that any money should be welcome, any profit, whether it's 5 million, whether it's 10 million, you should be able to move on from there, and that as an option. At the very end, or during the process, somehow the memo got back into us in October 2014. The price had reduced. There was aspect that says there would be some other work that would be given to LMT. And given the last point that was raised very strongly was, look, you head office, you can really tell us up to a point in terms of who we should work with. But if you're going to hold us accountable for performance, project performance, you can't really fully dictate the in terms of who at the overall we should go with. From where I'm sitting, with the price having reduced, with a possibility that a portion of some of the work in the bigger Hoefester platform would go to LMT, I ended up supporting the memorandum, which was not for my memorandum, was for the CEO to sign. Because commercially issue had been addressed, it seemed as if LMT would get some bit of work, and I signed. On the day I signed, the supply chain executive was not at work, was on leave. But my understanding from where I'm sitting, these issues were fairly common to my issues. The issue was overall the price, which was out of line, and when that got into a certain level, and I was quite satisfied to sign it off.
Now, what was the outcome of the discussions where you had voiced your objections to the business going other than to LMT? Was that resolved?
The misgivings were not so much about LMT versus VR. I barely in those days knew who was behind VR Laser. I mean, I only learnt more when I was suspended. It was more about the understanding I had about the capability of LMT. My understanding, some design work of the very same product had been done by LMT. That was.
And was it also about a principle, namely on your understanding, if a company that's part of the group can give us a certain product or certain services, we should not go outside of the group unless there is really proper justification.
Precisely, Chair.
Okay.
Now, your affidavit has referred to the issue of price, and the Commission has already heard evidence that in relation to the tender to which LMT and VR Laser and another tenderer had responded, that initially there was approximately 100 million rand difference. LMT was tendering approximately for 160 million rand, whereas VR Laser was approximately 260 million rand. Now, did that have any bearing on your view that there were concerns that LMT should not be awarded the tender?
My challenge with those initial numbers was the gap in prices. And I was of the strongest view that you would rather be, even if it meant that there was sort of support we needed to give the LMT, assuming that support was worth 10 million for argument's sake, we would rather be giving support to LMT and then award the work to LMT. So the price was my serious issue, and the second part was the group consideration. If there is a subsidiary or a division within the group that can produce the product, why would you take the product outside?
Now, did you eventually get persuaded that to approve the award to VR Laser?
It's not necessarily approving, because approving sat elsewhere. I needed to maybe not to be saying I'm opposing it.
You decided at some stage not to persist in opposing or in objecting.
The opposing as a process went on for 3 months, from roughly around June to October. And in that process, we met the key people within the LMT and DLS. We went on to meet with Pamotsi, who is an investor within LMT. And what was at the center of the conversation was a very clear message that we would want the work to go to LMT. If DLS has issues, can they specify what those issues? Can LMT rectify the issues? At the end of the, and also that it was LMT consideration, there was a price consideration. At the very end, the price is now reduced. LMT, at least in the understanding, was that LMT would get doors and frames, which is another part of this work, as a different package. And therefore, at that point, with the third element of a very strong point that was being made, that says, we desire to go with VR Laser as a division. If you are now stopping us from going with our supplier, with having met your price requirement, then we cannot be held technically responsible for any shortcomings if the work is not done to the standard that we want, which we don't believe that LMT would do. And on that when those arguments were on the table, then I had to back off. But what is interesting, just the last point, is that the very same program that obviously VR Laser was advanced as the solution today is 8 years late. So I mean, I would have been drawn into that part now if I had insisted on my position.
Well, the argument that you allude to, which seems to have ultimately either persuaded you not to insist on opposing or objecting, at a certain level one can understand it. But namely, if the management at DLS were going to be accountable for the performance, one can understand at a certain level if they say, well, don't hold us accountable if you insist that we use an entity that we have concerns about. Allow us to use an entity that we have confidence in, and in that event, if anything goes wrong, you can hold us accountable confidently. But at the same time, one says, why did they want your views? Because if the position is that the decision lay with them, anyway, you were expressing your views, and you were not saying that you were going to take away whatever power they had to make a decision. So I have those two reactions to their argument. It's at a certain level, it's like it was to say, shut up. Shut up, because we are the ones who will be held accountable in the end. But then if you don't want our views because they don't agree with your views, why did you want to hear from us? That's the two reactions I have to the argument. I don't know if you want to say anything about the two reactions.
I think, Chair, they would say, we have listened to you, Fikile, in this case, because you queried the price, now the price is reduced. You have queried why are we taking the work outside. We have scratched around. We have found the other work that we would give to the entity within the group. This is a safety critical issue, and we believe it should be done by that particular company because it has the competency. They're going to say, we met you halfway.
Yeah, well, certainly they can say they did something, but I would have thought that when they do that, the part of argument that says, look, we will be held accountable, don't insist on your views when we are going to be held accountable. I would have thought that they would simply say, look, we have gone a long way to try and accommodate your concerns. In the light of all of this, do you still have a problem, And if the concerns if you think that the concerns have been adequately addressed, you might say, no, look, that's fine. But it's just that they say, look, we are the ones ultimately accountable. But it might be much of a muchness. Mr. Kennedy?
Thank you, Chair. Now, Mr. Mhlontlo, you've referred in your affidavit to the views of Mr. Lumbo. He was the Group Executive for Supply Chain. Is that right?
Correct.
Was he, in the hierarchy of Denel, was he junior to you?
In the structure, he was reporting to me.
He reported to you. May I take you in another bundle, not the one in front of you, just put that one in front of you to the side, please. Chair, may I refer him to a bundle that was admitted by you previously when Mr. Lumbo gave evidence, and Ms. Malashlela. It should be headed Denel Bundle 1. You could open that, please, Mr. Mhlontlo. May I take you, please, to page 791. So for the record, it is Denel-01-791. Mr. Mhlontlo, may I ask, were you able to hear the evidence of Mr. Mhlontlo 2 weeks ago?
I only heard the first part where he was going into detail around this part. I couldn't listen to it.
Okay. Now, he referred in his evidence at page 791 to this email that came from him. It was addressed to Mr. Saluji, as well as to yourself and Jan Wessels, the COO. It's dated the 9th of September 2014, and I'm going to summarize the contents before I ask you to comment on it. He says, I've managed to review DLS's submissions pertaining to the above-mentioned subject, and you'll see in the headline, the subject is the awarding of Hull Manufacturing Contract to VR Laser Services. And then he raises certain issues. He says the following issues paint an unacceptable picture from a process, fairness, an objective point of view. The first paragraph refers to the tender documents not being sent to all the bidders simultaneously. The second is that there were separate engagements or clarifying sessions with individual bidders rather than all at the same time. The third relates to the triple BEE status, where LMT's triple BEE status was disregarded because it was not verified, whereas the VR laser certificate was accepted and rated 2 days after the closing date. In other words, that they were not treated equally. Then the fourth point, he says this, if I may read it into the record, it says in the submission, and his evidence was that this was the submission that came before him and others in senior management requesting approval for this award to VR Laser. He says in the submission, it is claimed that LMT's quote is too low and unrealistic. The difference between LMT's quote and the VR Laser quote is almost 100 million rand. After questioning Stefan Nel on the accuracy of his quote, that of course was the then head of LMT, on the accuracy of his quote, he offered to come and present the facts to demonstrate that it is based on realistic quotes. Furthermore, he claimed that LMT had made the hull before under Patria's contract. And then 5, in my meeting with Stefan Berger yesterday, he of course was DLS's CEO at the time, he indicated that VR Laser had offered to reduce the quote from around 262.4 million to 195.0 million, with an exclamation mark. Doesn't that tell a disturbing story about the initial offer? On the basis of these findings and other facts, it is my considered opinion that the submission from DLS be rejected. Since LMT has the capability to make the hull, this issue should have been discussed further before going out on tender. Now, do you recall, Mr. Mhlontlo, receiving this email that was addressed to you and Mr. Saluji and Mr. Wessels?
Yes, I do.
And did you read its contents and did you take them seriously?
The contents were read. One aspect that it talks to, there is a price, there is a LMT, there is our process issues, which all of these issues were taken into account before that final memo was signed off. But more importantly, in the meeting, this the very email was asked to what extent these issues have been cleared, and there was a position that I don't fully recall. Either it said the matter was either cleared or was in the process of being cleared with Dennis. It's a pity that on the day he was not at work when I signed it. But when I signed that memo, it never at all meant that these issues needed not to be closed out. Materially, from where I'm sitting, the price was significant. The fact that it had reduced, it was important. There are issues in my affidavit that I'm covering that are saying how it got to reduce is also another matter altogether, which I was not privy to in terms of how practically it reduced. But the price had reduced. LMT seemed as if it was going to get another package, and those were material. And there was a broad point that says Dennis has issues. To what extent are you either addressing or have addressed these issues? Our understanding was that these issues would be addressed.
Do you know whether they were addressed satisfactorily?
I mean, of what happened, obviously, after awarding that work, give or take October 2014, I never got a feedback really that we sat down with Dennis and myself and say, has these issues been fully addressed? But lastly, Chair, the memo of October 2014 that we initialed, it had the supply chain, at least divisional executive, signing that off, which went a long way in ensuring that if we are given assurance that these issues will be addressed, that we had faith that they would be addressed.
I'm going to come back to Mr. Mlambo's role and responsibility and the concerns and whether they were resolved. I'd like to just focus, before we move on to that, just for a moment on the reduction of price. Now, Mr. Lumbo made a comment, obviously felt it important enough to raise it in a letter, and he used exclamation marks, etc., to emphasize his feeling of real concern that there was initially approximately 100 million rand difference. And it's significant. We're not talking about this being 100 million rand compared to a 100 billion contract. This was 100 million between approximately 160 million tendered by LMT and about 260 million tendered by VR Laser. And Mr. Mhlombo seems to find it very disturbing that VR Laser should be so way above LMT in the first place, yet LMT is not going to get the business. But secondly, he's disturbed, seriously disturbed, by the fact that when there were discussions between Denel and VR Laser, and that resulted in it bringing its price down from 260 odd million to 195 million. Now, what he suggested in his email, and as he explained to the chair 2 weeks ago in his evidence, oral evidence, is that he was especially disturbed about that. That how can you get a tenderer who is serious, dealing with a public institution such as Denel, presumably giving a competitive price, if it is actually a genuine, fair competition, competitive process, not engineered and not maneuvered to favor one? How can it come in with 260 odd million and then be persuaded just a few weeks later, oh, well, yes, we'll change it by about 70 million rand to bring it down to 195 million? Those are the concerns that Mr. Mhlombo expressed in his email briefly, and of course he's elaborated that in his oral evidence. Was that a matter of considerable or any concern to you as Mr. Mhlombo's boss?
It was a huge concern. When the memo was brought to me and brought to the COO, this is the issue that led to the 3 months of back and forth. Price for me was to say, no matter how good the quality could be, that better quality cannot be 100 million more expensive. And then there were engagements, there were workshops, there were clarification. Lots of emails were exchanged between my office and DLS and even LMT for that matter, where these issues were being voiced out. My stance has been leaning on the side of ensuring that you save the money for the fiscus. But at the end of the day, with a huge pressure from the division that had a responsibility to execute this project, with the price having reduced and with the LMT becoming very clear that would be catered for, it was only on that basis that I signed the memo. But also in the meeting was to say, but by the way, there are process issues, there are certain issues that Dennis has raised. To what extent have you raised those issues or addressed those issues? And there was an assurance that they would be attended, or they either were being attended to or had been attended to. But the central to his email and his issues are aligned to what were my issues.
Now, apart from the fact that VR Laser was about 100 million rand more in its tender compared with LMT, the fact that it was given an opportunity to negotiate a reduction, a major reduction, from about 260 down to 195 million, was that, in your view, acceptable from a legal and particularly a procurement point of view, to actually engage in negotiations?
In a tender process, you would have your criteria. Your criteria would talk to whatever, maybe quality, would talk to timelines, would talk to all the factors that you deem critical. And you would also have a price, fee, and everything else. Even that you look at all of those issues and you tick. For me, it remains the issue around the price was now reduced and the LMT was now being considered. But getting to your point, if at some point you would go in what you call best and final offers. And that process, you go to all those who have tendered. Now, let's say, in terms of quality, because of concerns, LMT was no longer a feature because they fell short on quality. You would then go to VR Laser and go to the next supplier, go into a best and final offer, and then you take it from there.
Now, that was not done here, Mr. Mhlontlo has testified. Do you know whether that was done? Whether both VR Laser and LMT were invited to give a revised best and final offer?
What the investigators have shown me are the emails that are being exchanged between the ELS management and VR Laser in particular, and which suggest that process was, in all likelihood, I think more internal emails between management and within DLS, which suggests that they may only have gone to VR Laser, which renders the process unfair.
Yes, I mean, presumably, let's assume for a moment, and I'm not sure that necessarily it would comply with Treasury regulations, but let's assume for a moment that it is permissible, once tenders have been submitted and opened, that it is permissible for an entity like Denel to go back to the tenderers and say, would you like to revise your tenders? The evidence that has been presented before the chair has been that only VR Laser was approached. Mr. Mhlontlo has also explained that it is permissible if, for example, a tender has been awarded, so the decision has been made to award a tender to a particular entity, then it may be permissible, once the decision has already been made, for the entity to go back to the tenderer and say, would you be prepared to bring down your price? Maybe we can push up quantities or whatever to make it worth your while. So there is a latitude, and I believe the Treasury regulations bear him out on that. But what appears to have happened, and that Mr. Mhlontlo has commented about it here, is that VR Laser was approached when its price was so much higher than LMT's. Despite that, where the scores that they received from the evaluation committee were less than 1% difference, where LMT was going to save Denel 100 million or so, that VR Laser is then approached on its own and said, would you like to bring down your price? And they say, yes, we'll bring it down by 60 million or so. Now, it seems that opportunity was not given to LMT. Who knows, maybe it would have been prepared to reduce its tendered price by 60 or so million to bring it still 100 million below VR Laser's revised price. But did you believe that this issue of offering VR Laser on its own the opportunity to revise its price, were you aware at the time that that was irregular, as seemed to be hinted at by Mr. Mhlontlo?
It is also hinted by myself in my own affidavit to say that if you are to offer best and final, you're going to have to give it to the tenderer that you, maybe one or two or three, that you would have shortlisted in order to just a step before you make your final decision. And if that process was afforded only to VR Laser, not to number two, and because in terms of the ratings, LMT was number 3. So instead of not giving it to your number 2 as well. And also, if we look at the issue of quality that I deal a lot with in my affidavit, that there was a concern that from a technical point of view, they wouldn't be able to produce the product. So let's take for the purposes of this session that the LMT had fallen out already, but you needed to have given the opportunity to both tender number 1 and tender number 2. And as I had no knowledge that they only had gone to one supplier. And I've learned as I sit at home, as I've got presented the evidence, is obviously they were only the only ones that were given the opportunity, rendering the process once again irregular.
So were you not aware at the time that in fact LMT was not given a similar opportunity?
Chair, I want to make this point. In my affidavit, I deal at length that DLS had rated LMT negatively on technical aspects, went on to produce evidence that came from UN for some of the work that they had done for UN, and then given that and the issue of the fact that they would be accountable for the product, it then narrows the suppliers really to one, the VR laser, to the supplier number 2. And if I was the one running the process, I would then go on into best and final offer to the 2 suppliers. It served no purpose for LMT to reduce their price because they were low anyway.
Well, if they were prepared to go even lower, that surely would have served your purpose as a state entity trying to avoid asking for yet another bailout from government. Surely,
No, well, precisely.
Yeah.
I'm pointing out that I was not aware of that communication, how it unfolded. Some of the emails going so far as to say, I will get VR laser prices reduced, I'll use other means to get to them. Now, to me, it sounds as if VR laser was too close to DLS, and those aspects were not as visible at the time of signing that memo.
Yes. Now, Mr. Mhlontlo then raises all of these issues in the email. Ultimately, you came to be persuaded to sign the revised memo at a stage when you believed that these issues had been addressed. Is that right?
Correct.
Yes. Did you ever have a discussion with Mr. Mhlontlo, either by email or in person, and he of course reported to you, to ask him these questions that you have raised that are serious, that Mr. Mhlontlo, actually shares some concerns about? Dennis, Mr. Lumbo, have your concerns been addressed? Have they been resolved? Did you ever discuss that with him?
I would think that in our normal engagements, I would have brought him to speed around what we had done, but I don't recall specifically a session where we took this email, went on a point by point, to say all issues are resolved. But I guess we were both executives. Maybe that's where we missed doing that. Either I should have gone to him or he should have come to me, and then we can reconcile these issues.
Would you agree that Mr. Mhlontlo, although he was junior to you, he still occupied a relatively senior position within Denel?
In terms of the executive for supply chain, was a relatively newish position. Executives for supply chain, if it didn't come into existence late in 2012, would have come late in 2013. So the position, maybe by the time he left Denel, had really matured into a well-understood role, given its own powers. But perhaps in its infancy, there was also a bit of finding fit.
But would you not agree that where he has been appointed, he was already then the group executive for supply chain? If he, reporting to you, has raised with you and the group CEO and others concerns in the email, would you agree that they needed to be taken seriously?
I had fundamental issues that I made it a point that they were taken seriously. And these issues, his issues and my issues, are not materially at variance. And that's an important point.
Yes, I accept that you shared many of the concerns that he raised. Can I ask you, please, in the same bundle, that's still bundle 1, Chair, that you've just been handed up, page 612, in fact, the document starts at page 604. Let's start there. And the Chair has already heard the evidence of Ms. Malashlela, who was the then head of supply chain in the entity DLS, and she indicated that she was instructed to prepare this revised memorandum despite her own concerns and misgivings about the procurement process. But she, on the instructions of the DLS executive, prepared this, and this motivated for the approval of the award of the platform hull contract to VR Laser Services. Now, if I can take you to page 612, that appears to be your signature at the foot of the page. Is that right?
Correct.
And that was dated the 16th of October 2014. And so you signed, you didn't give final approval to it yourself because that needed to be approved by Mr. Saluji. As we see on the top of the next page, you were part of the slightly lower ranks within the organization who were expected to either recommend or not recommend approval. Is that correct?
Correct.
And you recommended approval by Mr. Saluji. And the analysis is set out of the tender process and the evaluation and why it was submitted or recommended that VR Laser rather than LMT should be awarded the contract. Now, it's interesting to see the date on which you signed that. That's the 16th of October 2014. That was about 5 or 6 weeks after Mr. Mhlombo's email that I took you to earlier at page 791, and that is the 9th of September 2014. So, am I correct in understanding your evidence a bit earlier to the Chair that after Mr. Mhlombo raised his concerns in his email, many of which you shared, you were engaged in a process where you understood those concerns were ultimately remedied, at least sufficiently to be persuaded to recommend us?
The specific meeting that signed this memo, it was one of the items that got discussed. And whereas the price is now reduced, whereas there is an indication of another package that will go to LMT, and the question was, has all the Dennis's issues been addressed? Because my fundamental issue was the price. My fundamental issue was the work not going to LMT.
Yes, now mention was made by Mr. Mhlombo of the fact that in terms of the delegation of authority, any contract to be awarded worth more than 200 million had to be approved by the full head office board, the Denel SOC Limited board. Is that correct?
I would need to be referred to the delegation of authority. And as far as I'm aware, the delegation of authority worked in a cascading order, where 0 to a certain amount, it would be the division. From a certain amount to a certain amount, it would be Dennis Mhlombo. Above a certain amount, it would be myself. Above a certain amount, it would be the CEO. And I do not recall in those years the acquisition, any specific acquisition that needed to go to the board.
Okay. Well, he has given evidence in relation to that specifically. If I can ask you in the same bundle to turn to page 757. This is part of the delegation of authority, which starts at page 752, the table, and then it's 757, 5.1. Do you have that?
Yeah, I have it.
So that gives, as you put it, a cascade of levels. So anything below or equal to 50 million would have to be approved at a certain level. Between 50 million and 200 million at another level, that would be approval. The A in a column headed GCE, the A according to the key is approval. So that means that anything between 50 and 200 million would have to be approved by the GCE. That was Mr. Saluji at that stage, correct?
That would be correct.
And in the right-hand column, it says Group Supply Chain Manager prior consultation on procurement above 20 million.
Yeah.
Group Supply Chain Manager, in fact, was meant to read Group Supply Chain Executive. Mr. Mhlontlo gave evidence. Do you have any difference of view on that?
In fact, if I look at this, it suggests that it escaped.
I'm sorry to say that again?
I'm saying that if I look at this,
Yeah.
it means that it fell exactly in the GCO approval because it was 195 at the end.
Yes, well, I'm not asking you that yet, Mr. Mhlontlo. Perhaps you can just indulge me to answer the questions that I am putting to you. I'm getting to the point in a moment about where the 195 fell. If you can just indulge me, the last category is over 200 million. The approval no longer was vested in the GCE, but now had to be approved by the board, correct?
Correct.
And it says in the right-hand column, a report outlining the process followed to invite and shortlist suppliers and evaluation and scores of the shortlisted suppliers and recommendations of the tender committee to be tabled at the board for approval. Now, let's go back to your point about the 195. Do you have any comment on the fact that it just seems rather interesting, perhaps coincidental, that VR Laser initially tendered at 260 odd million and was now persuaded in a process that you've acknowledged was not fair because LMT wasn't given the same opportunity to then to revise its price. It does so quite dramatically and then just happens to bring it down just below the requirement for the entire board approval. Do you have any comment on that? Or am I reading too much into it?
I mean, there could be two interpretations. It could be your very view, could be the view that's applicable, or it could be coincidental. It's difficult to say.
Yeah.
But yeah.
Yes. Now, Mr. Mhlontlo, let's go back to the issue that we were debating earlier about the information that you got, because Mr. Mlombo had raised concerns. You had your own concerns, which coincided with the substance of Mr. Mlombo's concerns. And then when you signed the recommendation, as we've seen, if you go back to page 612, that was 5 or 6 weeks after Mr. Mlombo's email, and you were given assurances. Now, I just want to take you back to your evidence earlier. Are you saying that Mr. Mlombo did not take part in the meeting that took place in October when you were ultimately persuaded to join in the recommendation of VR Laser?
Mr. Mlombo on that day, on that week, I think, was on leave.
Yes. I don't know if you heard Mr. Mlombo's evidence 2 weeks ago, but certainly the chair did. But Mr. Mlombo said he understood that his advice given in his email that the award to VR Laser should not go ahead because of the concerns that he raised, many of which were shared by you. He understood that management would be acting on that and consistent with that. And he found to his surprise that at this meeting in October, just 5 weeks later, this was in fact approved, recommended and approved, despite his concerns, which were not resolved. I don't know if you heard that evidence, but the clear effect of his evidence seems to be he's employed to do a job, he's employed to advise senior executives, including yourself and Mr. Saluji, that there is a serious problem in different aspects, as he set out in his email, and that it shouldn't be awarded to VR Laser. Now, I accept, of course, that Mr. Mhlontlo didn't have the final say. It was subject to approval either by the board if it was over 200 million or by the group's chief executive. But he clearly had a feeling that of being offended and undermined, that behind his back, as it were, a decision is taken to approve the very thing that he had strongly recommended shouldn't be approved because there were serious irregularities. Now, he wasn't consulted, he said, before the decision was taken. He wasn't asked, or nobody came back to him and said, Mr. Mhlontlo, on your point in paragraph 2, you're completely wrong, you've misunderstood the facts. Or on point number 3, we've actually resolved it. We've actually invited LMT to revise its offer, for example. None of that was done. Were you aware that that was not done with Mr. Mhlontlo?
I'm going to, Chair, go back to the process that around June, July of 2014, a memo came to my office, a memo I rejected on the core grounds, which are the same as that Mr. Mhlontlo raised. A series of workshops and conversation took place, a lot of emails which endeavored to ensure that LMT ended up with this work on the basis that is within the group. And also at the very end, the quality issues were raised by ELS, and when we met on this day, 3 months down the line, the pressure was huge, and the point was made to say that if we delay this aspect any further, it would begin to impact the office project, and a number of the issues that I had raised had been mitigated, and there was a specific question posed to say, yes, Dennis had a supply chain process related issues, and to what extent those have been raised, have been addressed, and then there was assurance that I can't quite recall whether they either have been addressed or in the process of being addressed. Dennis, Mr. Mhlontlo, was an executive within a group of executives. His inputs would be considered, but his input isn't the final input. And I think that's important.
I think the point that Mr. Kennedy seeks to canvass with you is not that Mr. Mhlontlo's view or input was final. I believe it is simply that approval was given without his issues being addressed. I think that's the point, to say if the final authority to approve rests with somebody else, that's fine. But if I've raised issues and they are legitimate issues by virtue of the position that I hold or the job that I'm doing, at least somebody needs to engage me on these issues. If there is engagement and we don't agree, maybe that's fine. But what are the answers to my questions that should be addressed. That's my understanding. Mr. Kennedy might indicate, that's my understanding of the level at which he is raising it, because that's what I would also expect. If you are counted among the people who must be consulted, and you take a different view from everybody, at least there must be an engagement, or somebody must address your concerns. It doesn't mean that they have to agree with you, but you must have that engagement at least. Otherwise, you might feel like, so whatever input I make doesn't matter. Or worse, you might think some people were just going through the motions because maybe they've got some predetermined outcome that they are pursuing. Because if somebody says, here are the problems to following this route, and others follow it, at least they must be able to say, these are our arguments against his arguments. Are you able to say anything on that?
Chair, if I look at my concern and look at his concern, look at the issue of one aspect of it around quality that I couldn't talk to. Being a finance, I wouldn't talk to whether their quality of welding is appropriate or not.
Yeah.
To the extent I'm provided with evidence around quality that almost excludes the LMT, there's not a hell of a lot I would be able to do there. The price, which was a concern for me, had reduced. There was an indication that even though quality is an issue and therefore they cannot be trusted with this package, but there is another package that would go to LMT, it was on that basis that I had signed. My understanding was that material aspects of what Dennis was concerned with had been addressed, but I also posed the question to the divisional leader of DLS to say, by the way, as you are now converging us in this room to sign, have you addressed, or are you going to ensure that Dennis's issues are addressed? And I'm saying if we then did not necessarily, at some point, Dennis and I sit down on an email on a point by point, it's our fault, both of us, because we needed to have done that.
Because as I understand it, and you have made the point at least 2 times or more, to say there was a serious overlap between your issues and his issues, or they may have been substantially the same. And it seems to me from what you are saying that you got persuaded partly because you were told either that his issues had been addressed or they were being addressed, plus the issue of the price, and then there were the quality, the technical, those were the, otherwise substantially you and him were on the same side.
Okay.
Yeah. Okay. And one doesn't know whether it so happened that the meeting happened when he was away, or whether it was engineered to be like that, because it's well, maybe I shouldn't say it's strange. Here is somebody that is quite seriously opposed to this thing, and this crucial meeting happens when he's not there. But it may be that it was coincidence. It's just that also it's strange if even when he comes back, he finds that his issues have not been addressed. You know, it might have been different if when he came back he found that when he looks at the minutes, it's clear that somebody said, well, this is our response to this and that and that and that. But, yeah, okay, thank you. Mr. Kennedy?
Thank you, Chair. If I can just for completeness refer you to page 785. "785 appears to be another email from Mr. Lumbo, which in fact was sent before the one that we've looked at. I'm not going to go, Chair, through the detail of it, but this again is a letter from Mr. Lumbo, in this case addressed primarily to Mr. Stefan Burger, CEO of DLS, but he copied in Ms. Malashlela and yourself, as well as Mr. Wessels, Tubis and Saluji. And this raised similar sort of issues. Can I just go back for a moment, Mr. Mhlontlo, to the issue about LMT and its quality and reliability? You've mentioned that there were concerns raised that, for example, LMT had caused embarrassment because it had produced vehicles for the United Nations which turned out to have technical safety problems. And other witnesses have given evidence in relation to that. But are you aware that in the evaluation of the tenders, LMT was not rejected, it was actually scored on the basis of its technical capability. It did not score as highly as VR Laser, but it wasn't found to be so bad that it couldn't be used by Denel. Are you aware of that?
No, I wasn't aware of that, but what obviously in amplifying the problem, in trying to make the problem appear maybe big, that was evidence that was produced to us by the division, and a lot more in this regard. Chair, the division concerned must answer for itself.
Yeah, but it seems that some in the division, not everybody, but some in the division, DLS, seem to be saying, well, we've got to give it to VR Laser because they're the only people who can do the job properly, technically, because LMT is really not reliable. But that wasn't a view shared by others. And in fact, there was the further issue about LMT being acquired by Denel, so it was now going to be in-house and could now be controlled by management, and it was being assisted in terms of an advance payment for another contract that it was still working on. So it seems that Mr. Mlambo may have had some substance when he said, but why are we not giving it to LMT, especially when it's going to cost so much less and where technical issues can be managed? Was that something you went into, or was that something on which you felt you were guided by other people to a point that you were satisfied?
If we consider my affidavit, I'm very strong on this very point, that I wanted this work to go to LMT. At the end of the day, Denel in those days operated in a decentralized setup. Divisions had to account for their own revenue, had to account in terms of the project execution and completion. And even though I was so strong on that, I do say in my affidavit that with all the pleas and begging and coercing, I was not successful, and at some point I had to let the process go.
Is the position that if the power rested on you to make a decision, you would have made a different decision? In other words, you would have given it to LMT, but you kind of deferred to the people in the particular division, or what is the position?
So if I was both the CFO of the group and I happened to be the MD of that division, I would have given it to LMT, no doubt. Yes. Even with specific mitigations I would have had to put in place.
Yes, okay.
Chair, may I just ask a few more questions just to complete this line, if that would be acceptable? Okay. I see it is 1 o'clock, but if
that's fine.
Promise to just ask a few, and then we should be able to move on from this. You see, what I find important, Mr. Mhlontlo, is that this was not a decision that was vested in the division. We've already looked at the delegation of authority. If it was vested in the division, it would have been left to Mr. Stefan Burger. And it's quite clear from the documents that Mr. Stefan Burger believed only VR Laser should be given this contract, despite the arguments against that were raised by various people, including yourself. But surely the reason for delegating the authority for an amount of so much to the group CEO, based on the recommendations of inter alia yourself as group CFO, was that this was a matter of such importance because so much money of the group's money, which is of course public money, was being spent. It wasn't left to Mr. Burger. So don't we have a situation where you effectively seem to be saying to the chair, unless I'm misunderstanding your evidence, you seem to be saying, I as group CFO, when I was asked to make a recommendation, I would have liked to have recommended LMT, but I was persuaded to rather recommend VR Laser, despite all my serious concerns. And the reason why I was persuaded to recommend was simply that the head of the division wanted VR Laser, whereas the head of the division didn't have the power. It vested in you. Surely you were there together, and I'm not suggesting you alone, Mr. Saluji and others. Surely you were there as a safeguard for Denel's interests to ensure that it wasn't just a divisional head steamrollering you and getting their way to prefer an entity such as VR Laser. But you had to be satisfied that there were very good reasons. And if there weren't good reasons, if there were concerns like you, to your credit, had, that they needed to be properly answered before the decision could go the way that Mr. Burger wanted.
Chair, the recommendation from myself as to the process to proceed to go to the overall approver is informed by a number of considerations on my side. One, the price had reduced to a number. Secondly, there was a package that would go to LMT. Thirdly, there were various technical issues that were pointed to be the issues. And there was no way of in particular, of going against those technical issues that were pointed, at least based on the information that was before myself at the time. So if I then have a letter that says, as this company would do this work, there is this letter from a client that states the following things. Then as a division, we've evaluated at a point in time, this letter has come, and is such that we cannot entrust this to LMT, given that correspondence in terms of letter, price having come down, the fact that there would be other work going to LMT persuaded me sufficiently to be able to say, to give it the sign off. And if we look at the other aspects that I've now become aware of now, obviously, if I was aware of those facts at that point, there was no way I would have signed it off. I feel, Chair, that really I've put my position around the matter.
Well, it seems to me that based on your answer, you are conceding the point that Mr. Kennedy makes, but you seek to defend your decision on its own merits, leaving aside the issue of deferring to the division. Is that correct?
That's correct.
Okay.
One final question, if I may. Mr. Mlambo's emails effectively was saying this process has not been fair. You seem to have confirmed that the process was not fair, in at least the respect that VR Laser was given the only chance to amend its price. Effectively, of course, if a tender process is not fair, it is contrary to the Constitution, Section 217, which says that any state entity such as Denel has to follow a process which is fair, equitable, competitive, etc., cost-effective too. Now, was Mr. Lumbo, who reported to you, was he not ringing a bell, an alarm bell, saying, this process can't be awarded to VR Laser because it is unfair? And you would have known, surely, Mr. Mhlontlo, as a chartered accountant and as a senior executive of a state entity, that if there was an unfair process in a tender award, which you were being asked to recommend, it would firstly be unlawful, and secondly, it would be subject to legal challenge in a high court. Weren't you recommending something that you'd already been warned by Mr. Lumbo, and which you shared his feelings, should not be awarded precisely because of that?
Chair, I recommended that for overall approval on the basis of 3 points that I've articulated, with the full understanding that the matters that have been raised had either been fully addressed or in the process of being addressed. There is absolutely no other information that was available to me other than those points. I then indicate that as I was at some point during the course of this year or last year, the investigators are pointing out internal communication that had taken place within DLS that indicates that this business was too close to DLS, and the process could actually have been irregular. It is up to the DLS divisional manager who must take a stand at some point and account for this.
Chair, would this be a convenient time? Take the adjournment.
Yes, let's take the lunch adjournment. We'll resume at 2:10.
2:10. Thank you, Chair.
We adjourn.